You want to do a probation with Mr. Proctor?
That's what he said, Judge.
You couldn't even stay out of trouble. You're on bond. Why do you actually think that you can make a probation?
Oh, you got someone else.
Yeah, I've heard that before. How many times have I heard that before? How many bond violations have we had, Mr. Proctor? You know, you can lie to me, but you can't lie to yourself. You know, if you think you repeatedly fail to appear for court, you repeatedly fail to comply with bond conditions, how on earth do you think that you're going to be able to make probation where you have to do classes, have to remain clean, you have to report once a month? You can't even report to court once a month. How are you going to do this for 12 months? History says otherwise, Mr. Proctor. Can we do a TRAS? Before I do anything, I don't know how to go forward with him. And I think that probably the best way to see is to have Mr. Proctor evaluated to see what conditions and what is the appropriate way to go forward, because I have no idea what's going on in your life. I have no idea what you have, and we don't want to see you fail, Mr. Proctor. We want you to leave better than you came. But just doing this right here, it's just throwing you out there to the wolves. I mean, if you really think that this is the appropriate way, you can even, while you're on bond, for a couple months, stay out. Before, I would like to have him evaluated. So what we do is we have clinicians available that can interview you, talk to about you, what's going on with your life, what has been happening with you, how everything has transpired and how we've gotten here to this point, and to see what's the best way that we go forward. Do we need a treatment plan? Do we need inpatient treatment? Is it sufficient to do out? I don't know, but I'm not ready to do this just yet. I think that we need to have the QRAS to see how we go forward. Let's see what they say, and then at that point, you want to court reporter regardless, right?
Oh, no, sir. No, sir. We will respectfully honor the
So let's
request by the court.
It doesn't have to take long. I can expedite it so we can have everything done within the next couple of days. We're not talking weeks. We're not talking, so we can have everything done quick, because I don't want you to just sit there and languish. But I need to know how to go forward. And this, I don't think that this is the appropriate way. If they say after we have you evaluated, if they say and they give the blessing, then I'm all for it. I want to do what they advise because they know best. Every time I have someone TRAS and I deviate from it, we pay dearly. So that's why I trust them to give us the best advice as how to go forward. All right? Give me a couple days. Let me get the TRAS done. We can come back and then we'll go forward. Okay?
Thank you, Judge.
So she's on bond for an assault of a family member.
Yes.
On bond for a felony assault of a peace officer. And now you pick up a new case.
And what happened was she went to felony.
Oh, hold on. I don't even think we've done probable cause yet. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and or $2,000 fine.
Thank you. On March 19th, 2025, a law enforcement officer observed a white Chevrolet Silverado ahead of him on the block 600 block of Wilcott Parkway and ran the license plate through the NCIC TCIC. Registration was shown to be expired as June 2024. A traffic stop was initiated and the law enforcement officer made contact with the defendant, the driver. The law enforcement officer observed a strong odor of marijuana, and the defendant claimed at first she didn't have anything in the motor vehicle, then confessed she had marijuana and several pipes. The defendant was detained. The probable cause search of the motor vehicle was done, and the law enforcement officer located multiple marijuana pipes. The law enforcement officer located a small bag of a leafy green substance and a black bag in the back seat. It was identified as marijuana and the bag was within arm's reach of the defendant. Total weight of the marijuana was 0.09 ounces.
Since she has a license.
Yes, Your Honor. It does show be
Eligible or
ineligible.
ineligible? You're not allowed to drive. You will now be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what your excuses are. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and or a $500 fine every time you drive. You are on bond for 2 cases. Your first bond violation report was filed in February for you not showing up for testing and not picked up a new case. I now revoke your bond on the assault case.
Judge, if I may,
Please.
she went to felony court and she was also revoked there. She just spent probably 4 or 5 days there. Is that
Yeah.
right? And she's out here.
The
So
day that moved was I was in jail for a traffic ticket and a call.
I don't know if you heard that, Judge, but the day that she missed court here the first time.
No, I never missed the
You
test.
missed it. That's right. She actually had texted me and she got taken into custody because of a traffic ticket. I have all that. So she was actually on her way to the testing and got picked over, and therefore she couldn't continue to make it there. So she's already been punished for bond revocation on the felony court, which she spent 5 days in jail last week. When did you get out on that?
Saturday.
Saturdays. And so if we take her in, I know you have every right to, Judge. It seems to me like it's kind of like a double whammy for her, especially for the fact that for that first BVR, she did honestly try to make an attempt to get there. I have the phone records for that, Judge.
When someone tells me something and they repeatedly fail to recognize the conditions that we set forth, for me, it goes in one ear and it goes out the other ear. You telling me something when you get out the doors, you still do whatever the hell you want to do without regard to bond conditions in this court. I'm now revoking your bond. She goes with me.
It's my understanding that he left his area curfew area on 9:07 p.m. on 5/20 came back at 9:31, approximately 24 minutes. I spoke with him. It's my understanding that he went over to his sister's house because he and his girlfriend had gotten into a heated discussion. He informed me.
Mr. Joseph.
He informed me that he left to stop proceeding assault or possibly assault between the two.
I do everything in my power to try to prevent people from going back into custody. But some people just refuse to just, I don't know what I can do to get your attention. You now have 2 open cases, and now this is your second bond violation. What do I need to do to get your, what do I need to do to get your attention? Is it putting you back in jail, Mr. Joseph, and making your bond high? Your actions tell me different. This is what we're going to do. I'm sending him now for a drug and alcohol test. I want to know what, if anything, is in the system. You were to come back. If you fail to test, if you fail to take the test, if you fail to come back, it's not going to go well for you. Do you understand? I don't want you to say anything. I want you to go take.
I'm offended. I'm not time for let's get on my sister back.
You have been on bond, Mr. Joseph.
Okay, so yeah.
I think the last time he was in court, Judge, I think he made an admission that he had used drugs during that court appearance. And if that's the case, he may be correct in that it may still be in his system, Your Honor, because it hasn't been 30 days.
The first burglary of a motor vehicle has been open since June of 2024. Since that time, I have told you not to use.
Okay, I'll.
Take a seat for me. I don't know what we're gonna do. Take a seat.
Thank you, Terry.